pair of sneakers, you could be walking in one of this man's many patents. He'll explain why a law now in the works could mean big changes for independent investors.
I'm Paul Kangas.
And I'm Susie Garoff. This is Nightly Business Report for Friday, November 9th.
Nightly Business Report.
On the news tonight, Susie.
Paul, there's legislation in the works on Capitol Hill to modernize the U.S. patent system. Congress hasn't updated it in more than 50 years. The House passed its version of the bill in September, and the Senate is expected to vote on the measure by the end of the year. But as Dana Greenspan reports, independent inventors worry the new law could work against them.
This is one of Kobe Bryant's basketball shoes.
Frampton Ellis has his hand in what a lot of people put on their feet.
What I discovered was that when you...
More than a decade ago, he set out to invent a curved shoe sole that minimizes ankle sprains.
This is the first professionally made prototype.
One eureka moment and many hours of tinkering later, he scored a patent and licensed his invention to Adidas, giving him a foothold in the shoe industry. So everything here, everything we're looking at in this case, uses the technology that you patented.
Yeah, I think so. And they made many more shoes than this, actually.
But he says the current patent reform bills moving through Congress would create hurdles for inventors like him.
If the patent system was changed as it's currently proposed, I mean, it would basically, I think, terminate the careers of most independent inventors. I mean, it would force them out on a cost basis.
In particular, freelance inventors worry about a provision that would make it easier for other companies to challenge a patent's validity repeatedly over the course of the patent's life. That would delay an inventor's ability to recoup costs, and it could create an additional financial burden. Another provision would strictly limit the amount of money an inventor could be awarded in a patent infringement case. Companies like Microsoft and HP support the legislation. HP's Michael Holston says the changes aren't meant to push out the little guy, but rather to dry up the flood of litigation companies like his have faced for years.
In the last 14 years, the number of patent lawsuits that are filed in the United States has tripled. We and most large companies are under attack and expending tremendous amounts of money defending these cases.
HP spends about $50 million a year defending patent suits. Many are brought by so-called patent trolls, people who buy up patents from bankrupt businesses, then bring infringement cases against big companies. But patent attorney Robert Stern says the legislation may push the system too far in the other direction. He says those infringement issues have already been dealt with elsewhere.
My concern is that with all the changes at the Supreme Court and at the Patent Office, that the patent system could be severely damaged in terms of its effectiveness for the little person, the innovator.
Even independent inventors like Ellis admit the patent system is flawed and needs tweaking. But he says the current legislation could prevent the next Google or Apple from getting on its feet. Dana Greenspan, Nightly Business Report, Washington.
Companies like this drug maker say market exclusivity guaranteed by the U.S. patent system is key to their business. We'll look at issues straining that system as we continue our series, Copy Protection.
I'm Paul Kangas.
And I'm Susie Garoff. This is Nightly Business Report for Tuesday, November 20th.
Nightly Business Report.
Susie?
Paul, while artistic and literary works like this program are protected by copyright, inventors rely on another form of protection, patents. As our series Copy Protection continues, Dana Greenspan reports the patent system is straining to keep up with rapid changes in technology.
For more than a decade, scientists at Panicos have been on the cutting edge of HIV research. The company's major discovery? A drug called Beveramat, which prevents the HIV virus from maturing and becoming infectious. The hope is that Beveramat, patented in 1997, will become the first effective treatment against drug-resistant strains of HIV. COO Graham Alloway says the patent system is key to his company's growth.
Clearly, for a company like ours to be able to develop such a novel drug, we need to be able to have some element of market exclusivity through the patent system. The reason for that is it takes many years and many millions of dollars to develop a drug for any indication, certainly for HIV.
Market exclusivity is a hallmark of the U.S. patent system, which gives patent holders control over their inventions for 20 years from the date the patent application is filed. To obtain that patent protection, the inventor needs to show the U.S. Patent Office that an invention is new, useful, and non-obvious. The process can take anywhere from 12 months to 5 years. and the average cost, including legal fees, ranges from $6,000 to $25,000 for a single patent. Panacos holds 9 patents in the United States and has another 19 awaiting approval. The company is constantly on the search for new patentable discoveries. So now, what are you guys doing in this one?
Well, this is where we are doing some of our major drug screening.
So when you're searching for new potential compounds in here, you're also sort of searching for new potential patents.
Absolutely.
Panacos illustrates how it's possible to register many different types of patents for a single product. Of the 6 patents the company has for Vivaramat, only 1 is for the chemical compound itself. The other patents range from the process used to create the drug to the part of the HIV virus the drug targets. John Dudas is director of the U.S. Patent and Trademark Office. He says today his office not only receives more types of patent applications, but also more complex ones.
The applications grow in complexity every year. So what you saw 20 years ago were certainly simpler technologies than they are today, and there's so much more technology out there today, which is a good thing for our economy, but it's a challenge for our office.
A challenge the office has tried to address by hiring 1,200 new examiners a year. Even still, each year the office is swamped with about 450,000 applications. Only about 50% will result in patents.
The House will be in order?
Congress is now considering a bill to reform the patent system. High-tech companies like Microsoft and HP support the bill. HP's Michael Holston says there's a need to update a system that hasn't seen sweeping changes for more than 50 years.
Making a long-distance telephone call was high-tech in the 1950s, and as the law has evolved and things have changed, there's just a tremendous need to go back and revisit the system.
Graham Alloway of Panacos agrees the patent system is imperfect, but he's concerned that proposed reforms might weaken existing patent protections.
If we didn't have patents, our value would be sort of less than 10% of what it is, because really the patents are an indicator of the value of all the ideas and the programs that we're developing.
But getting a patent isn't always the end of the process. A patent can be challenged in court, and the number of patent cases in U.S. courts has gone up by almost 50% over the past decade. Dana Greenspan, Nightly Business Report, Gaithersburg, Maryland.
This program was made possible by contributions to your PBS station from viewers like you. Thank you.